All right, welcome to the second of the appellate court videos that we're trying to put together to help you guys prepare for the conference. What we're going to do today is just to remind you some things about what it'll actually be like to present your case before the court. And what I'm going to do is present two kind of mini versions of what you will see when you do the appellate court. The first thing I'm going to do is for the prison official side, or the respondents, and I'm going to address the compelling state interest in prison security question. Then we're going to stop, and I'm going to present the second side, which will involve the question on least restrictive means. Basically what you'll see is I'm going to roadmap my case like I encouraged you to do in the first video. We're going to have about 5 minutes where I'm continuing to present my case, but the justices are going to interrupt me with questions, and then you'll hear the person presiding over at the Chief Justice say, you have about 45 seconds left, would you like to summarize? And at that point they'll stop questioning me and I will summarize that. We will do that twice so you can see a little bit of how each side might put together a case, and then this will be available for you to watch as you're moving up towards the conference. And so if you watch the first videotape, this should sound familiar with the way I'm starting. You'll start all of your cases with the phrase, "May it please the court," and so in just a second you're going to hear me say that phrase, and that'll indicate that we're ready to get started. May it please the court. My name is Greg Snowd, and I will be representing the respondents in this case. I will be arguing that officials who represented the Department of Corrections have met the burden of proof required to show that the grooming policy in question furthers the compelling government interest in prison security. I will show that the testimony of the officials clearly establishes a compelling government interest. I will be reminding the court of the requirement that it give due deference to the testimony of prison officials. And finally, I will demonstrate that the existence of a quarter-inch beard exception for medical reasons does not undermine our position. So, on to my first point. Prison officials have clearly demonstrated the grooming policy is necessary to ensure prison security. They have done this through several pieces of evidence that they presented. They were concerned about possible escaped prisoners altering their appearance. They were concerned about hiding narcotics in their beards, hiding weapons such as razor blades, needles, homemade darts, etc. was a potential security concern, and concerns for the security of Mr. Holt, that he might be singled out, and concerns for the safety of security guards.
Counsel, wouldn't you say, though, that because of the policy of having hair being as long as to the nape of the neck, that a beard that is only half-inch would not be a beneficial, compelling reason to ensure penal security because of the idea of the hair being even longer than the beard?
I think the prison officials addressed this in their testimony, and again, remember, it's with all due respect, the court must give them due preference, as the Cutter decision clearly talks about, and they're not concerned about the length of that hair, but have clearly established that they're very concerned about the quarter-inch beard. So giving due deference to the prison officials.
What is this due deference?
Excuse me?
What is this due deference?
Due deference basically means what was established both in the law passed by Congress, in which Congress clearly said that due deference must be given to prison officials, and the idea being that in the case of that we're talking about now, the court should never substitute its judgment for that of the prison officials. So if the prison officials are concerned about the half-inch beard and not about the length of hair, both the law passed by Congress in the legislative history and in Cutter, we're required to give due deference to those prison officials.
Thank you, counsel.
And if we,
Counsel,
just moving on, because my second point is on
Counselor, could I interrupt
due
you
deference.
before your second point? Now, while we are required to give you due deference and the prison officials due deference, we're not here to rubber stamp all decisions made by the prison officials. I would like to hear an answer to my learned colleague's question. How come the hair is not a more dangerous hiding place than, say, a half-inch beard?
I mean, I would, with all due respect to the court, it is the half-inch beard policy that is before the court right now. If at some point a prisoner wanted to grow their hair longer than what's allowed in prison, then certainly that would be something that this court could address. What I would say is due deference, which is going to be my second point as well, which I'll move on to momentarily. would indicate that if the prison officials are not concerned about the length of the hair, we also have to give them due deference. And if their concern is this litany of concerns that they have about the half-inch beard, ranging from prisoners escaping and altering their appearance to the ability to hide small homemade weapons like razor blade and homemade dart, then the court, based on Cutter and the legislative history of the law in question, must give deference to the court. And if I may proceed on to that point, that the court must give prison officials due deference and cannot substitute its judgment for that of experts in the field. The legislative history of the law in question clearly indicates that the Congress intended courts to give deference to the expertise and experience of prison officials, and that in Cutter versus Wilkinson, this is reinforced that this deference would dictate that courts must be sensitive to security concerns.
Counselor, what is your comment on the fact that 44 of the 50 states allow prisoners to grow beards because of religious reasons?
I mean, the court, in precedent that is before this court, the Supreme Court has never required that just because one state's officials are not concerned about a certain part of their grooming policy, that all states have to follow that. I mean, basically, we have to address these on a case-by-case situation, and prison officials know their prison environment within their particular state and locale the best, and so their judgment is based on how, in this case, a grooming policy plays out in their location. The fact that another prison official in their judgment is willing to allow beards has never been used by this court as a reason to compel changes in similar policies. And if I may, because this may also answer your question, move on to the medical exception that I know the appellant will be bringing up.
Counsel, you have about 40 seconds if you'd like to summarize.
I'm going to go ahead and summarize and also hit my last point at the same time. So undoubtedly the appellants, just to summarize, will be bringing up the fact that we allow for a medical exception, a quarter-inch beard. And I just want to be clear that the testimony of prison officials have clearly said that that medical exception deals with a much smaller percentage of the prison population, that it is temporary and treatable, and because of those differences, the quarter-inch policy does not undermine my broader point, which is that the prison officials' testimony has clearly laid out the security concern that they have, and because of their experience and expertise, the court, as in Cutter and the legislative history of the law in question, must give them due deference when the court might disagree with their opinion, but they must side with the position of the prison officials when they have presented evidence to show their burden. Thank you.
Thank you, counsel.